We are instead talking about a new ruling by a federal judge against, or at least tossing charges against some drug users over their ownership of firearms. And this is a pretty interesting case, deals with the federal prohibition on, I guess, habitual drug users owning firearms. You wrote about this, Jake, so you know the details here. Tell us what happened.
Yeah, so it's sort of just the latest in a string of cases that we've seen calling into question many of the prohibiting offenses listed under the Federal Gun Control Act of 1968. So in this case, as you said, it was a criminal case that was being reheard now in light of Bruen, where a West Texas woman was arrested because when police were called to her home to investigate a separate domestic disturbance, they found a bunch of marijuana, some psilocybin mushrooms, as well as multiple firearms and ammunition. And this woman admitted to police that she was a habitual user of marijuana, which under current federal law is illegal. It's technically a prohibiting offense. It asks you specifically about that on the background check.
Yes.
And she admitted to owning the firearm as well. So she was charged with being an unlawful user of an illegal substance while possessing a firearm. But this judge tossed the charges and said that was actually unconstitutional, that provision right there, because it doesn't comport with our nation's historical tradition of firearm regulation, which is the Bruen standard.
Right. And I guess the main reason that the judge found it wasn't in line with historical tradition of firearms regulation is because it's a total prohibition on gun ownership for life, right?
Yeah, that's right. So there was the state or the federal government, for example, cited a few colonial era laws, one in Virginia, one in New York, that were about alcohol use and firearms, but it was mostly the crux of it was basically you can't shoot your guns while you're drunk, right? You can't be drinking and fire off your guns. And this judge said, well, that's a little more narrow than this ban that completely bans you for life if you occasionally consume a substance that in many states is illegal now. She made an analogy that it would be like for our current DUI regulations, if we completely banned car ownership for folks that occasionally drink alcohol on the weekends, was sort of how she related that.
Right. It's interesting because this is another criminal case, right? Where we're seeing the effects of Bruen, because it's certainly not what I would call a great test case. It's not the kind of case that if you're, a gun rights activist who wants to overturn the marijuana prohibition, you probably wouldn't choose this case because it wasn't just marijuana involved. I think the husband was also addicted to crack cocaine, and I believe they were also accused of threatening people with firearms as well. So, not your sort of model plaintiffs, I guess. But this is another instance where you've seen sort of these wild card appearances of Bruen in lower courts because they're not, these aren't planned cases like you would have from the Second Amendment Foundation or the NRA or the, Firearms Policy Coalition or GOA or whoever. Instead, these are criminal proceedings. Do you know if the lawyer was a public defender in this case?
I don't recall off the top of my head, but what is interesting is what prompted this sort of revisiting of these charges was the Rahimi case, which is what we've covered previously, was the ruling that struck down the ban on gun ownership by folks that have domestic violence restraining orders on their record. Because that ruling was handed down, it opened a door in this proceeding to revisit these charges. Because I guess this defendant had previously tried to get these charges dismissed and the courts weren't having it. But then once Rahimi came down, they were able to then go back, revisit it under the Bruen test. And this was the result. So I think that's interesting.
Yeah, that is interesting. So you're seeing the effect of that precedent in the Fifth Circuit already. Now, of course, the Department of Justice has appealed Rahimi to the Supreme Court. And that might actually be the next Second Amendment case that the court hears, because there's a sort of preferential treatment given to the government, the federal government, in appeals to the Supreme Court, because then, generally you don't want to have a federal law enforced differently throughout the country. And so we might well see Rahimi as the next big gun case at the Supreme Court. And it'll be really interesting to see where the court actually comes down on that, because it's not, it's certainly not one of these. We've talked about before how the court has been behind public opinion on gun policy in a lot of their main cases to this point. Heller was 2008 and said you can't totally ban handguns. And that was well after the public had already turned against handgun bans, well after that happened. And same thing for Bruen, which was about gun carry. You basically can't, whether completely or effectively, eliminate the ability for most people to legally carry a firearm. And that too was well after there was a long-term societal shift on that question from, the 1970s and 80s, where you basically couldn't carry concealed anywhere in the country, or the vast majority of the country, to, right before Bruen happened, where almost half the country was permitless carry and most of the rest was shall issue, meaning if you could pass the background check and do the required training, the government had to give you a permit. And so there are only 8 states left with the may issue policy that got struck down in Bruen. So it'll be interesting to see where the court comes down when it's not such a popular position to get rid of a certain regulation, because domestic violence restraining orders, while the Fifth Circuit talked about some of the legitimate concerns involved with associating those orders with a ban on gun ownership, I would imagine those are much more popular positions generally in the American public. Now, obviously, that's not supposed to matter as a factor in deciding a case, but I think it would be maybe a little bit naive to think that it doesn't matter at all in how the court looks at these things. So We'll have to see. And same with this one, right? I think there's probably a lot more support for removing marijuana from the sort of substance that makes you prohibited person who can't own guns, while, if you smoke weed. But the rest of those restrictions, I don't know that there's nearly as much support there, right?
I was going to say it's a funny phenomenon that's happening where these criminal cases are coming up with all this new Second Amendment jurisprudence because defense lawyers are using the Bruen test basically to get a lot of their clients off. And as you said, it's hard to see public opinion being so closely aligned with the outcome of these cases as it maybe is under Heller and Bruen, like you said, because not only do you have a crack cocaine user getting off under this test, you have domestic violence restraining order, people under domestic violence restraining orders being allowed to own guns. There was a felony indictment. The ban on gun ownership by folks under felony indictment was struck down in a separate case as well. Right. So you're just seeing a series of these criminal cases where it's hard to imagine public opinion being aligned with the outcomes.
Yeah. And so that's where you're going to see, I think, a real test of the court's willingness to stick closely to history and tradition, or at least we'll see what they interpret the tradition in being, and how how loose an analogy can be before it becomes, too far out to justify a restriction. So I think it'll be interesting to watch the court handle that question. And Rahimi itself was a criminal case as well. It's kind of a weird one too, because he's charged with so many other crimes that are very likely to make him a prohibited person anyway, that it's a bit strange to see this case even be filed or challenge this particular restriction, because he's facing 5 different felony charges for serious crimes. And once those are completed, he's not going to be able to own guns anyway. But I don't know. We'll see. We're certainly going to see how it all plays out. I think this is a win, certainly, for those who want to see marijuana removed from that list of things that make you a prohibited person using weed. There's certainly, I think there's plenty of people, and it's probably a growing constituency, who don't really see a significant difference between weed usage and alcohol usage. And there's obviously plenty of states where it's decriminalized, at least at the state level, to use marijuana recreationally. Certainly there's probably plenty of people in those states who don't think they should be banned from owning guns for life because they use marijuana recreationally. But again, this case goes beyond that to harder drugs as well. So we'll have to see where it all comes down.